Good morning, everyone. We will get started here shortly. Our meeting is scheduled to start at 11. I'll give it a few more minutes just to allow folks some time to get logged in. I still see a few people popping in, so we'll just give it just a couple more minutes and then we will go ahead and get started. So.
Michael, this is Russ. You might want to make sure you speak up a little bit and stuff in the conference room there and stuff. It gets a little bit muffled and stuff there when you're speaking. So
thank you. We'll make sure to speak up so everybody can hear me. All right, well, good morning, everybody. I want to be mindful of everyone's time today, so thank you for joining us. My name is Michael Cunningham. I'm going to be the pre-hearing conference officer today. And this matter, of course, is for the Tucson South resource site, file number M2004-044, concerning a 112 amendment application submitted by Aggregate Industries. Amendment number 2 proposes to add 7.7 acres for a new conveyor route and remove 3.3 acres of unaffected land related to a former conveyor route to the existing 283.2 acre site. The application was received on September 9th, 2021 and filed for review on September 27th. During the public comment period, the division received 3 objections, and pursuant to Construction Materials Rule 1.7.4, Parent 2, the division has scheduled a board hearing before the Mine Land Reclamation Board, which will occur on January 19th of this month. Staff has made a recommendation to approve amendment number 2. Staff's recommendation and rationale was issued on December 27th of 2021. Today's participation in this pre-hearing conference is limited to individuals with party status. We will go over some introductions here shortly so we can make sure everybody is aware of who's on today's call. This is, of course, a public meeting. It is being streamed to YouTube, but participation in today's conference is going to be limited to those with party status. And if we do have any members of the media here this morning, welcome. I'd like to point out that Chris Arin, the DNR Communications Director, is also present in today's meeting. Thanks, Chris. And if you have any questions about today's proceedings, the application that's under review, or excuse me, the application for which staff has made a recommendation, you can direct those questions to Chris. We'll do our best to get you a response on that. Just a few other housekeeping items. If you go to the chat bar, I did put in Chris's email. It didn't quite paste as nicely as I did. So if anybody needs that, just let us know. We'll make sure you get that. I also note that Cami Mohar's contact information is on the sidebar as well. Cami is the board secretary. We'll go over what documents need to be sent to her shortly. And then I've also placed my email in the chat bar there as well. As we move through today's meeting, if folks could please be mindful to keep their mics on mute until such time as it's your turn to speak. That'd be helpful for everybody. And we'll absolutely make sure everybody has time to ask questions as we work our way through this process. So again, I've already introduced myself, but my name is Michael Cunningham. I'm a Senior Environmental Protection Specialist here at the division and will be today's pre-hearing conference officer. And in this capacity, I am representing the Mine Land Reclamation Board. I think I'd like to start by doing some introductions. That I'm going to start with Mr. Kooiman. I'll have him introduce himself, and then we'll go around and have staff introduce themselves. We will then move on to the operator and any representatives they have. And then we'll give the objecting parties a chance to introduce themselves as well. So, Chuck.
Yeah, so my name's Chuck Kooiman. I'm at the Attorney General's office, and I'm the attorney representing the Mine Land Reclamation Board.
Thank you, Chuck. I know we also have Division Director Jenny Brandon with us this morning. Morning, Jenny. Division staff, if you want to go ahead and introduce yourselves.
Good morning. My name is Jared Ebert. I'm a Senior Environmental Protection Specialist with the division.
My name is Patrick Lindberg, and I'm an Environmental Protection Specialist, and I did the review of the application.
And I'm Russ Means. I am the Minerals Program Director.
And good morning, everybody. Jeff Fugate. I am with the Attorney General's office. I'm here representing the division this morning.
Right, thank you. I think that covers division staff introductions. If we could have someone from the applicant operator introduce themselves and the folks that are present, that'd be great. Whoever wants to jump in, anybody go ahead. Oh, Gary, I see you talking, but I think you're on mute there. And I just got a message from Michelle that she cannot unmute herself. Anybody else having that difficulty with?
It's okay. I took care of it, Michael. So
Okay.
they should be able to unmute now.
Thank you.
Okay, thank you very much. I'm Michelle Berger. I'm with Spencer Fain. We represent Aggregate Industries on the application and the hearing. And I'll just have the Aggregate Industries folks introduce themselves, and then we also have our engineer, Gary Linden, and some other folks that have been working on this application with Aggregate.
Yes, I am Gary Linden. Can you hear me now?
Yes, we can. Thank you.
So I worked on the application. I worked with Patrick and Michelle. So I work for AI. Thank you.
I'm Neil Whitmer with AI. I'm Director of Land and Environment.
Jackie Clark, Lafarge Holcim, Government Affairs for the region.
Wyatt Webster, Environmental Land Manager.
Roger Wingate with the Matrix Design Group, performing construction project management for Aggregate.
All right, very good. Did that cover everybody for Aggregate Industries?
I think, excuse me, Michael, I think my associate Brendan Desmond is also on the line. I'm not sure if he is having problems unmuting or just didn't get a chance to introduce himself.
Okay, thank you.
Yes, sorry, Brendan Desmond with Spencer Fane.
Okay, very good. If that covers introductions for Aggregate Industries, let's go ahead and move to our objecting parties. Ms. Gould, I see you on the call. Would you like to start us off?
Am I vocal now?
Yes, ma'am.
Okay. And when you say start off, just introducing myself,
Yes,
or
ma'am. Just let us know your name and who you are.
I'm Cherie Gould. I'm a business owner and a homeowner, and a very major stakeholder, very adjacent to this project.
Okay, thank you.
Yes, this is Wayne Mueller. And sitting here with me is Mike Lloyd.
Okay, good morning. I do believe that covers us for the objecting parties. Is there anybody on the call that I missed that has not introduced themselves yet? All right, thank you. So I'll briefly walk us through kind of the different things that we're going to cover this morning. The purpose of the pre-hearing conference is to describe the permit review process that was conducted by the division staff, to identify the parties, to explain rights and responsibilities of the parties in these proceedings. We're going to identify and discuss, and to the extent possible, resolve any of the issues that the objecting parties brought forth. And then we're going to establish the Mineland Reclamation Board hearing process. And included in that is going to be a proposed list of jurisdictional issues that the board will consider at the January 19th hearing. To the extent possible, we will try to simplify that list, and we will establish timeframes for how the hearing is going to proceed. So following the conclusion of today's pre-hearing conference, I will be drafting a pre-hearing order which touches on each one of those points. I will let folks know that I will have that draft pre-hearing order issued by close of business on Tuesday, January 11th. So you can expect to see it by then. The draft pre-hearing order is going to address, again, the hearing process, the parties that are involved, the issues to be heard, and a proposed schedule for the board hearing. Now, at that scheduled board hearing, the board shall consider the draft order for adoption, and the board, in its discretion, will hear any objections to the proposed pre-hearing order at that time, and they have the ability to make any necessary amendments prior to adopting that pre-hearing order. The board may also consider any pending motions, including an applicant's motion to exclude testimony at that time. So we've done our introductions, and I'll just go ahead and for the record read the objecting parties that submitted timely comments for this. Again, we had Mr. Michael Lloyd, Mr. Wayne Mueller, and Ms. Cherie Gould were our objecting parties on this application. I'd like to discuss just a little bit about the rights and responsibilities of the parties. At the board hearing, keep in mind that the parties must be present for that hearing. If you are not able to attend that hearing, you would forfeit your party status at that time. At the board hearing, you have the right to present evidence. You may call witnesses. You may cross-examine other parties' witnesses, and you may also be represented by an attorney. Again, it's important to note that later this morning, we're going to establish some timeframes that the different parties are going to have in order to present to the board. And the time that is allotted for you, just keep in mind that any time you use for cross-examination of a witness shall count against the total time limit that you have by that cross-examining party or the division. Any time used to respond to questions by members of the board shall not count against the time that is being allotted for your presentations. And finally, only parties may seek judicial review of a board decision. We have a few dates I'd like to cover with respect to motions. Should any of the parties desire to file a motion, parties wishing to file those motions, they must do so no later than 5 o'clock on January 11th, 2022. And those motions must be filed with Candy Mohar, the board's secretary. And again, her contact information, her email is in the chat bar. And additionally, when I send out the draft pre-hearing order, I will do so unless I hear any objections today. I will disseminate that to all parties present via email. So when that comes out, you will have a list of everybody that was in attendance for today's meeting. And I think that's going to be the best way for us to exchange any information that we have related to this hearing is via email. Again, unless I hear any objections to that. I think that's most expedient and probably easiest way for us to handle that. In addition to the motions, we have another date, which is responses to motions. So those must be received no later than 5 o'clock on January 13th, 2022. And again, responses to motions, as with the initial motion, should be filed with the board secretary. So now let's move on to materials that our parties are going to use for the hearing. So at today's pre-hearing conference, folks should have prepared for exchange witness and exhibit lists. With respect to our witness lists, if those have not already been submitted, please do so today. And those lists need to include a detailed list of each witness that you plan on calling for testimony, that witness's name, address, telephone number, as well as the subject matter of testimony. And then with respect to exhibit lists, similarly, we need to exchange those today. Copies need to be provided to all parties present. And so what that list should comprise of is for materials that are not in the division file, we need a complete list of that exhibit, a complete copy of the exhibit. And that again needs to be distributed to all parties. If you are planning on using an exhibit that is presently in the public file, this would be the online Laserfish file for the Tucson South site, then that list should describe each of those exhibits in detail. It should name the exhibits and should also indicate where those exhibits might be found by the other parties. And so with that, are there any questions about exhibit or witness lists? Do folks have those materials today? Are those ready to be exchanged?
Yes, Mr. Cunningham, we've provided our witness and exhibit lists and our exhibits to the division, and we can exchange them with the objectors after this hearing.
Okay, thank you. Jeff?
Yes, thanks, Michael. We'll do the same. I'm assuming we're just exchanging these witness and exhibit lists by email. The email's on record with DRMS. Is that correct? I'm sorry if I missed that.
Yep, that's correct. I haven't heard any objection to that, so I think that'll be the easiest way to handle that.
Okay, thank you.
And then from our objecting parties, are there any witness or exhibit lists to be exchanged today?
I will modify my list that I've already sent to Patrick. I'll give a little bit more detail and add what the witness is for.
Okay, very good.
This is Mike Lloyd, same here.
Okay.
I submitted the names, addresses, and emails, but I wasn't aware you had to include what they were going to testify to.
Okay. Yeah, if we could have your modified exhibits submitted by close of business today, 5 o'clock, will that work for you?
Yes.
I
Yeah.
just want, I'm sorry, can I speak?
Yes, please.
I just want to clarify on the witnesses. You have to list the witnesses and what they're going to speak on today.
Yes, we're looking for a complete list of who you're going to call, and then what their subject matter expertise is, or what they'll be testifying about.
Okay, and then can you clarify, is today midnight, 5 o'clock, 4 o'clock, what is that?
I think we could extend that to 5 o'clock today to allow you time to put that together if need be. Will that work for you?
Yeah, because I need some time for that. I did not see that anywhere. And I did send in my other stuff, and I'm waiting for, a confirmation saying, well, this is good, this isn't good, we need more clarity, or, because I want to get those T's crossed and those I's dotted, but I'm kind of new at this, so I'm just looking for direction.
Absolutely. I know there's a lot of information involved in this, probably a lot of information division staff sent to you. So if that works for you and you can get that together by 5 o'clock today and everybody's okay with that, then let's proceed with that.
We'll work on that.
Okay, thank you. So we'll ensure that all of those witness and exhibit lists get disseminated to all of the email addresses for today's participants. So that covers some of the upfront business. I think at this point, I will hand it over to Mr. Lindberg, who's going to give just a brief overview here of the permitting process.
Thanks. Thank you, Michael. Yeah, this amendment was received on September 9th, 2021. It is for a conveyor route to transport material mined at Tucson South, convey that mined material north towards the Wattenberg Lake site, which will then use an existing conveyor belt system to convey that material to the Platte Valley operations for final processing. We had 3 adequacy reviews that the applicant responded to all the adequacy issues in a timely fashion. And yeah, we issued our rationale for approval with condition on December 27th. And that condition is related to tracts of land where county approval is pending. And that condition states that land should not be affected in Tract L, Tract O, and County Road 23.5 until final crossing designs are approved by the respective county and documentation of that approval has been submitted to the division. Are there any questions?
All right, thank you, Patrick. All right, well, now we're going to move on kind of to the meat of this morning's meeting here. And what I'm going to attempt to do is summarize the outstanding issues that we have that are going to be discussed at the board hearing. And then following that, we will have a discussion about the time allotments for the parties that will be presenting. I'm primarily going to be using as a reference point the division's recommendation and rationale document, which I trust everybody has a copy of. This was sent out on December 27th, 2021. So I'll move through this point by point, and then I'll pause after each one, and we'll make sure that we've got consensus on these issues. The first issue for consideration by the board deals with the availability of amendment application documents for public review, and concerns whether or not those materials were publicly available as required by rule. Are there any, I guess let me start with our objecting parties. Does that accurately capture that particular concern? Is there agreement with how I've characterized that?
I'll speak to that. I think that that kind of summarizes it both in what was posted and not there at times, and then there right before an inspection, and then the publishings that were available to those who sought them out were under headings that were like notice of election and demand, or, you know, just not pertinent. They weren't under it. And whether or not that was an accident or convenient accident, it's hard to say. It's just not what I felt was, it should be a standard that should be allowed.
Thank you.
I have one more comment. As recently as last night, the division website that contains the documents crashed continually and wouldn't allow me to search for documents. I had to reload it at least 6 times to get to all of the pages of the documents. That's not quite adequate for public.
Thank you. Ms. Gould, do you?
Yeah, I wanted to add to this at this particular point in time. I understand the DRMS with their 200-foot rule, and obviously people who don't drive down Tucson Street would never know this. I had reached out to the county multiple times asking for updates as to where things were at. Even though they had received updates, they were completely unaware, don't know why. But at the point that I finally figured out and told the county, yes, you in theory have documents that have been delivered there, and somebody should know about this, because when I checked with the clerk and recorder, she said, no, we don't have anything. And I said, well, you know, according to the DRMS, you need to find them. So she had to dig and find them. She offered to get copies for me that amounted to about $150. And I have gotten more comfortable with being on the DRMS site. I know that that's been over several years of use, but that is not in any fashion that your ordinary citizen could utilize that or be able to read it or to compare it or to do anything with it. The only way you could actually view this was to make an appointment during the very limited times that they were open, to go down there and read 500 some pages. And I just thought that's just not right.
Okay, thank you. I think I understand your concern, and I didn't hear any objections to how that first topic was categorized. And Ms. Gould, I think you touched on the second point of this topic, which is the publication notice being miscategorized online.
Correct.
Okay, so thank you.
I do want to say one other thing. I had worked, and Patrick was very helpful in trying to find various ways to get the files to me. And that in itself was a series of number of emails. I actually didn't get the final file till the day that comments were due. And again, that part of actually being able to get the whole thing, the DRMS site does not allow you to download a complete file. It has a limit to the number of pages, so you have to keep going back. There's not any instructions on the DRMS site that tell you, well, here's what you can do, and here's how you can do it, and then here's how you can combine it to make it one complete file. And I'm just saying that as an FYI to an area where I think the DRMS could make improvements that would benefit the public that they serve.
I appreciate your comments and suggestions. Thank you. I guess before we move on to the next topic, I just want to see if the applicant has any comments on these particular topics, as well as division staff. Is there any common ground here, opportunity to resolve this, or anything folks would like to add?
So, Michael, this is Michelle Berger. I think that Ms. Gould, in her final comment about this being more of an FYI to the division, is probably a more appropriate, summation of this issue. It's not really whether or not the applicant made the documents available as required by the rules and regulations. It's more, I believe, the user friendliness or accessibility of how the documents were stored either on the division's website or at the county's. And the publication notice being misplaced, I believe that that has been followed up with by the division and determined that that was an error on the part of the Brighton Standard Blade, not the applicant. So I would, as the applicant's attorney, ask that this not be an issue that is presented to the board as being relevant to the application that is being heard.
Yes, this is Wayne Mueller.
Go ahead, Wayne.
One more note, since we're doing a little housekeeping here. The notices were sent via certified mail as per required. Michelle did what the state required her to do. However, the people out here are on rural mail routes. We change mail carriers like Orville Redenbacher popcorn. Mail is commonly misplaced, reported as delivered, and never been delivered. The simple expense of about $1 to get a return signature would guarantee that people got what they were supposed to get. My son, who is not here because he's not currently a party, he did not complain, did get a letter that showed it was scanned, never got it. And I know for a fact how some of the mailings went, because I got another piece of mail that wasn't even coming from, from my address for 2 of my neighbors. That was on that same time that we were, basically supposed to be getting this. So assuming that the people that are directly affected have received adequate notification is not correct. If you have a return signature, then you know they got it. Without that, you have no idea.
In hearing from both sides on this, what I am hearing is that this remains a point of contention. Public notification is a jurisdictional topic, and so I do think it is appropriate to keep this as an issue for discussion in front of the board. I don't want to spend too much more time talking about the specifics or the merits of that, but I understand that this is still a point of contention, so we will keep these issues on the list for consideration for the board. And with that, I'd like to move on to the next topic here. This is related to mining plan issues. We have a concern expressed about the limits of extraction at this mine site as it relates to extraction within the slurry wall cell. And I'll just give Mr. Mueller a second here to get set up. So Mr. Mueller, I do believe that particular topic was expressed in your objection letter. Is that
the limits of extraction? Let me apologize. The charger on this computer died while you were talking, so we were fixing that. Limits of extraction. Yes, that was a concern. I understand the division says the materials will only be used. There'll be nothing extracted other than the materials for the crossings. I'd like to see that as part of the permit, because all you said there is that the material needed for construction will be removed. The division finds the applicant completed. This applicant has a history of mining outside of slurry walls on an adjoining property and extracting mineral. I want that in their permit. They can use no materials outside of their current permit if this is granted.
Okay. And so that it sounds like that accurately captures your concern here. Is there any comments from division staff or from the applicant on this particular topic?
No comments, Mr. Cunningham.
Okay, thank you. Also, under the general topic of mining plan issues, we had a concern expressed about public signage posted at the mine site and whether that was adequately posted. And again, I believe that was expressed by Mr. Mueller in his objection letter. Is that accurate, Mr. Mueller?
Yes, it is.
Okay. Thank you. Any comments from any other parties with respect to permit signage at the site? Ms. Gould?
Yes, I do. In my attachments to my letter, I had included previously, because this particular application has a very long history, complaints registered both by the city of Brighton and residents throughout time regarding the missing signage. This has been an ongoing issue for years. And if you follow through and see when somebody actually came out and inspected it, the sign would either show up or would be noted. And I thought it was kind of odd. It'd be like somebody saying, I'm going to come check to see if there's drugs in your whatever will be there in a week or two, and it gives them plenty of time. But it was noted multiple times throughout the history of this Tucson mine that this has been an ongoing issue, and yet the documentation and the files always magically seem to not show that this was a violation in their permit.
Okay, thank you. So I understand it's still a concern. We will have this on our list of items to be discussed in front of the board. Moving on to the next item under mining plan, we have concerns about whether or not the operator has complied with permit conditions that have been imposed on the Tucson South resource site. Mr. Lloyd, I believe this was an issue that was raised in your objection letter. Is that adequately capture what your concern is?
Yes, basically, I'm going to defer to Mr. Mueller to really comment on this item.
On which one? Okay, on this one as to final specification for slurry walls. I'm the adjoining landowner. When these modifications were made, I was never notified. I got nothing from the applicant. I got nothing from the state. I didn't have any idea this was going on. And I had no reason to go sit down and look at the division's website on a daily basis to see what was happening. The redesign of the slurry wall, we don't know what it was based on. There's groundwater monitoring that has happened. There's all kinds of things that have happened. But we never got notification that was going to happen. The other comment was we have serious questions about the basic factual conditions used to do the design and to come up with the parameters for the design. And I'll save that for the board.
Thank you. I understand your concerns. In looking at the list of conditions that have been imposed on the operator, is my understanding, in reading through these seem to primarily deal with the construction of the slurry wall. As Mr. Lindbergh mentioned during his summary of the amendment application, amendment number 2 is focused on the conveyor corridor. So it is my understanding that any of these pre-existing commitments on part of Aggregate Industries were not directly related to amendment number 2. It's not what division staff was being asked to consider under this. So with that being said, are these issues that the objecting parties would like to present to the board with the understanding that this really is separate from amendment number 2? This was not under consideration by division staff. This was related to a different permitting action.
No, I will not agree to that. I contend that these conditions will affect the design, construction, maintenance, and operation of the conveyor.
Okay. Are there any comments from Aggregate Industries?
Yes, Mr. Cunningham, we agree with the division that the items in paragraph C, compliance with permit conditions, are not relevant to the current pending application, and believe that it's not pertinent to the board's consideration of the application. So we would agree with the recommendation that either not be considered by the board or be considered with the caveat that they were not considered by the board or relevant to the conveyor application.
Okay, thank you. Mrs. Gould, I see you have your hand up.
Yes, I just wanted to add to this, and say that while I respect these individual portions and pieces of this, the dynamics of this project that tie into what is going to now consist of an underground tunnel, County Road 2, going across into Weld County, changes literally the hydrology of so much here. And additionally, which I've supplied, the aspects of what is currently going on with the Challenger pit sitting just north of the Tucson pits also is significant. And the slurry walls, which are that is the nuts and the bolts of what affects the groundwater mounding and the flow and the direction that it goes to. All of this is very much tied together. And even though you can try to argue that, oh, well, this was addressed in 2004 or 2018 or whenever it was, they are interrelated, and there's a lot of things that need to be addressed. And I think there are safety issues that need to be looked at here.
Thank you. I think the conditions that have been previously imposed are clearly jurisdiction, it's within the jurisdiction of the board to hear that. With respect to the applicability of those conditions to amendment number 2, I think we will leave that to the parties to make their case in front of the board. So if there's no further discussion, I'm going to move on from the compliance with permit conditions to our next topic, which is a concern about berms and stockpile management, specifically a visual berm that was to be installed along the south end and west cell of this site. I believe that was a concern expressed by Mr. Lloyd. Does that adequately capture your concern?
Basically, yes. It really revolves around how the extra overburden is going to be removed from the site.
Okay.
And whether or not they just need to set aside the amount of overburden they're going to have to use in reclamation.
Thank you. Does AI have a response? Any comments you'd like to make on this particular topic? Is there any?
So I believe the berm that Mr. Lloyd is referencing is required by the conditional use permit. I guess I'm not entirely sure what the objection is here, or what he would like the board to determine as part of this.
Mr. Lloyd, if you'd like to respond, and if there is an opportunity to maybe resolve a particular issue, we would like to explore that if possible.
This comment also relates to the fact that this whole 200 and some odd acres, a lot of it is in the floodway as well as the floodplain. And there was a prior site of aggregate on the Tucson North Pit where they had a berm going exactly opposite what it should have gone to the floodway. And we don't want to see that repeated, because it took, they wanted months to remove that berm. And what happened was came down to the end of it, they removed it in 2 weeks. And it was a huge berm.
Okay, I appreciate that. I just want to be mindful of the time we've set aside today. We do have a number of issues to make our way through, so I just want to remind folks, we're not going to adjudicate anything here today. If we can resolve it, we'll do our best to maybe eliminate a topic, but this exercise is just to capture at a high level the concerns that have been expressed. So I'm hearing that berms and stockpile management remains a concern. I'm going to move on to the next topic. This is reclamation plan issues. We had a concern expressed about concurrent reclamation and whether or not that is occurring at the site. Does that accurately capture your concern, Mr. Lloyd? I believe that was in your letter.
It captures my concern. Again, my concern is that concurrent reclamation is not adequately defined.
Understood.
We looked at 18 years worth of non-reclamation on the Tucson North Pit.
we've got 3 topics. I'm just gonna, I want to move through these 3 topics for the reclamation, and then I'll certainly give the applicant an opportunity to comment on any of these if they would like to. The second topic is a concern about whether reclamation has been performed on previously mined areas. Mr. Mueller, I believe that was one of your concerns.
Yes, it is. And the question for the board is, when the applicant has said they're going to do concurrent reclamation, the parcel that I am concerned about was moved from one mine site to the other with the full intent to not reclaim it. When it was put into this permit, that was 18 years ago, it is still not reclaimed. That is not exactly concurrent.
Right. Thank you. And the final topic under reclamation plan issues is a concern related to the management of noxious weeds at the site. Does that remain a concern, Mr. Mueller?
It does, and that was part of the boards and the permits requirements. They have not maintained any control of noxious weeds on this since the issuance of the permit. This year, finally, after many complaints, they mowed them, but they didn't mow all of it. There is a large portion, if you were to go out there today, still have standing thistle heads distributing seeds.
Okay. I hear that this remains an issue then. With respect to the 3 topics that we discussed for reclamation plan, does Aggregate Industries have any comments on those 3? And again, the 3 topics were concerns regarding concurrent reclamation, whether or not reclamation has been performed on previously mined areas, and control of noxious weed species.
I'm sorry, Mr. Cunningham, I lost my connection there for a minute, but I understood you to ask us whether we had any comments on those last 3 objections, and nothing that would help resolve it today, but yes, we do have responses, so thank you.
I'm going to move on to our next topic, hydrology issues. And we have, from all 3 of our objecting parties, expressed concerns about groundwater mounding, as well as effects on adjacent wells and septic systems.
I'll defer to Mr. Mueller since he's one that's most affected.
My concern with the conveyor is that this particular conveyor is going to be placed in an area where we have very high groundwater. If we look at the prior application, the prior permit, and the hydrology that's been done, it all concerns the drying up of wells. Not once anywhere in any of the documentation does it specify anything about the detrimental effects of raising groundwater. There have been no hydrology studies anywhere concerning flow, height, volume, or change as a result of this conveyor, including crossing, the vibration to the existing structures, or what structures they're mounted on.
Thank you. It sounds, what I'm hearing is that we did adequately, that captures your concern and some of the issues surrounding the conveyor route. Also related is a concern on wildlife, specifically concerns regarding the conveyor corridor and the impacts that it'll have on wildlife. Does that adequately capture? And again, we don't need to go into details about the specifics of the concerns. Just does that seem to capture what the concern was, the potential impact of wildlife?
It partially captures that. One of the problems that I have with what was done with the Colorado Department of Wildlife is they were of the opinion that this conveyor was going to stop at the end of the extension of this current permit, not noting that it is a substantially increased distance with no current conveyor that is part of this project on a prior permit. So what was given to CPW does not appear to be factual.
Okay, so I am hearing that you have concerns about wildlife and you can discuss the details of that in front of the board. Again, I don't want to spend too much time on the specific arguments here. Ms. Gould, I see your hand is up.
Oh, no, just so long. I concur with what Mr. Mueller was stating, and we're moving on, so that's good.
Very good. Aggregate Industries, any comments on those last two categories that we discussed? General concerns to the hydrologic balance, groundwater mounding, impacts to adjacent wells, as well as impacts to wildlife from the conveyor route.
Thank you, Mr. Cunningham. As discussed previously, we believe that the hydrologic issues, groundwater mounding, were adequately addressed in the original permit and the subsequent studies, and don't believe that that issue is relevant to the conveyor, but looks like we're not going to be able to resolve that here. So understand that you'll probably recommend that the board consider that. And the wildlife concerns, again, we've met with the objectors. We've spoken to them about exactly what we're doing and why we believe that CPW supports us and accurately supports us. And again, I don't hear today that issue has been resolved.
Okay, thank you. Those issues will remain on the list for board's consideration. The next topic that we have relates to access agreements and a concern over whether the applicant has obtained all of the necessary agreements to install the conveyor corridor.
This has been a disagreement basically with the applicant for quite a while. And I'll defer to Ms. Cordova to comment on Westminster.
Ms. Gould?
Sherry?
Yes. For those who do not know me, my married name is Cordova. So, so in case there was confusion there, I am legally Sherry Gould. The access agreements, which I didn't note my name, but I've had a number of emails that have gone back and forth because there are issues both with County Road 2 and the Westminster site. Because while I understand that there is an active mining permit on the Westminster Wattenberg land, they do not have the right to use a conveyor on that land past June of 2022. And to me, that is a major concern because you cannot do any of this without that right.
Okay. So I hear this remains a concern, and then it sounds like your concern has been adequately characterized. So you'll have an opportunity to address the board and let them know how you see that. Any comments from staff or Aggregate Industries on this particular topic?
Yes, Mr. Cunningham, as I'm reading it, it says the proposed conveyor corridor will cross land owned by City of Aurora, Adams County, Yoshi and Susie, the Strucks, and Weld County. It doesn't reference Westminster. And what I heard Ms. Gould just say was that she has concerns with any agreements that might be necessary with Westminster, which that area is outside the affected lands. And I did not hear any concerns about agreements with landowners for which this conveyor is crossing their land and is part of the affected lands of this application. So I'm not sure how this subject is relevant or within the jurisdiction of the board, given Ms. Gould's statement just now.
Okay, thank you. Ms. Gould, if you briefly would like to respond, is there an opportunity to resolve this issue as it relates to Ms. Berger's response?
Absolutely not. There's more involved with just the conveyor agreement and all of the city of Westminster. This parcel cannot be ignored. It is crucial to the operation of what will be a very long standing mining project, and it needs to be resolved up front.
All right, thank you. We will have this on the list of items to consider by the board. I want to move on to the next topic, under which we have several subtopics. This is concerning geotechnical stability. We have a concern raised about the effect of the corridor on the stability of the Challenger Reservoir and a secondary concern expressed about the stability of structures near the reservoirs under rapid drawdown and saturated conditions. Ms. Gould, I believe you had expressed both of those concerns. Does that adequately capture what your concerns are?
Yes, and I'm sorry, I hit my hand to raise there, but yes, I think it does. And while I understand that there was a test conducted, the portion of the fact that the engineering that was done for the Challenger pit obviously was not adequate enough. I want to address the fact that this isn't a minor repair that needs to happen to that Challenger pit. The state write up on the failures on the Challenger pit addressed replacing of the clay liners on the entire pit, and the engineering studies that go along with that. I don't know that they have been done. And when I read the reports, it sounded like from the engineer's point of view, he took the assumption that there was certain things that were just there that should have been there with the standard reclamation. And I don't think that they were there. I don't know that there's anything to prove that what was used to do this, because I think that this test was done, but it took assumptions that I don't think should be used without doing actual testing.
Okay, thank you. Would AI like to respond or provide any additional information on those topics?
I don't think we can provide any information that will resolve this issue at this time, but we certainly will be prepared to respond to support our engineering analysis.
All right, thank you. That takes me through the list of items that we have received concerns on, which were determined to be jurisdictional. I do know that our objecting parties had raised some additional concerns regarding aesthetic impacts to the quality of life, as well as concerns regarding dust and air pollution. I will note that while I can appreciate that those would be concerns for many residents in the vicinity of a mine site, those particular issues are not under the jurisdiction of the division. There is nothing within statute or the regulations that allows us to address or regulate those. Those are typically handled at the local government level. So those will remain as non-jurisdictional issues, not to be considered by the board during this hearing. And that takes me through the list. Is there anything else? Did I cover everything?
I'm sorry to speak out because I'm not sure if my hand's raised or not.
Go ahead.
As I reflected through this, something that in letters, and I didn't get an actual legal definition of this, is when you write the objection letter, I have written objection emails in addition to this, addressing throughout this time the time factor that is proposed in this particular agreement. This is an agreement to do this within a very set amount of period. Reclamation, seeding, everything done all in March 9th, 2030. This ties into legal obligations contractually with the city of Westminster that Aggregate Industries is obligated to perform. There currently is only one conveyor that goes across the river. There's very, very tight timeframes. There is nothing of this size that has ever been completed in this amount of time. And I have addressed this, but yet it did not fall under, there was no comment in this reflecting this. And I definitely want to have the ability to speak on this in the hearing.
And to clarify, Ms. Gould, was this, what I'm hearing is it's a matter of a concern about the life of the mine, how long this site is going to be under operation before reclamation occurs? Is that?
It's a combination. There are multiple easements in expirations. There's obviously whatever may or may not ever exist on the Westminster's Wattenberg land. And then the situation and stipulations set down by the county, which were extremely specific, and following up on that is Aggregate Industries. All in, this was an extremely huge deal with the city of Brighton, with Adams County, and all the residents on this. Oh, we're going to be in and out. We'll be all done. And it's, I would like to present evidence as to how that is just not a factual statement in any remote way.
Does division staff have a comment with respect to to whether or not this was addressed in staff's recommendation and rationale or brought forth in any of the objecting letters?
Yeah, I've spoken with Ms. Gold a number of times, and we've had numerous emails over the last few years. And she's certainly brought up a lot of issues pertaining to easements and agreements that we're not parties to, nor can we speak to. And I'm still not exactly, sure I'm clear on exactly what regulatory function we have to impact this concern. So yes, has she raised concerns about timeframes in the past? I know we've spoken about it. I'm sure there's been in emails regarding it. But again, I'm just not clear on what regulatory solution the division can offer here. And yeah, so I'm not sure if that answers your question, Michael.
Yeah, it does. And I guess I just offer, I think Ms. Gould, I hear your concerns, and I think that, well, first I would just state that, when you're in front of the board and you're addressing this, you have to keep in mind that the board's jurisdiction is limited to the permits that we issue from this office. We can't adjudicate or make any sort of determinations on outside agreements that we're not involved in. And so, this is just a note to encourage you to try to focus on the aspects of this process that are within the board's jurisdiction, to make this just a more productive meeting. And what I'm hearing, though, is that, as a sort of a varied topic, but I think that this could be related to part of the discussion about all of the various access agreements that are needed. So I think we've got an opportunity under that particular topic to raise that issue with the board. I don't think at this time we need to break that out as a separate issue, but that would be your opportunity to discuss that particular concern with the board.
Mr. Cunningham, if I could just interject here, I'm not sure that I understand that Ms. Gould may have spoken to or emailed with the division about her concerns about Aggregate Industries' ability to perform under the conditional use permit. I don't know that those objections were ever forwarded to us as part of an objection letter, and I would hesitate to think they would be akin to the access agreements, because they're really Aggregate Industries' performance under a separate local land use permit, not our right of legal entry on property. So I would ask that you reconsider whether this is a jurisdictional issue that should be able to be taken up with the board, or whether it should be one of the non-jurisdictional items, because it is a condition of the conditional use permit, as are conditions that address aesthetics, dust, and air pollution.
Thank you for that clarification. Ms. Gould, if you would like to respond, please.
Yes, I would. We bring this back around to the amendment to this that is focused on a conveyor. The conveyor is our only ability to transport any of this material up to this Platte Valley site. And this is not going to run 24 hours a day. I could never get anybody to tell me the speed, how much it would actually, even if what's being proposed is, but we're looking at the avenue of actually mining this particular thing being the conveyor. So I do feel like that it is related, and the significance of the number of people that this impacts because of this is very important. If this was out in the desert or Timbuktu, who cares? But this is very significant, and it is tied to the fact that this is how they are saying we are going to mine this. We are going to use this conveyor. We're going to do this. And I'm just saying, this is the time frame in this, not just with the conveyor alone, but with all of those pieces. I get that there are extenuating things, but it is important. I think the point of this is to be there to serve and protect the people, and I think it needs to be looked at. And I just want that opportunity to let them make their own decision.
Thank you. I appreciate the comments from everybody on this particular topic. As I mentioned, I think the board is really limited probably in being able to speak to any other separate agreements that are out there. We can only address the permit that is being issued from this office or recommended for issuance and the life of the mine as it pertains to that. With that in mind, I do believe that this discussion does fall outside of jurisdictional topics. I will not be including this as a separate topic in there, but as I mentioned before, what I'm going to draft is simply that. It's a draft pre-hearing order. The board will consider whether or not to adopt it. And prior to doing so, there will be an opportunity from parties to express any concerns or object to anything that's in that draft pre-hearing order. And then the board will decide what amendments to make at that point in time. So we've gone through the list of issues. I know we're just a little bit over time. I think we can get through this last part pretty quickly. The next part does concern setting out timeframes for the different pieces here. So just, I know some folks haven't been through this process before. I just want to let you know kind of there's really three components to the hearing. The first part is an introduction, and that is always done by the division. So the division is just going to set the table for the board. They're going to give them some basic chronology and overview. There's not, in the introduction, there's no presentation of arguments or position. It is just simply, here's what we've got going on today. So that's what we start off with. From there, we move into our presentation. So each party is going to have an allotted time for presentation, and that'll be an allotment of time for the division, for the objecting parties, and for the applicant. And then after we get through presentation, all parties are going to have an opportunity for a rebuttal presentation. And then finally, all parties will have an opportunity for closing statements in front of the board. So we've got three different sections we need to deal with. We need to figure out the time allotment for each of those. I will note that when we are setting time aside for the objecting parties, that is for the objecting parties as a whole. It'll be up to you guys to the extent possible to try to coordinate your review or your presentation such that you can divvy up the time that is allotted for all of the objecting parties. And to that extent, to try to minimize as best possible any duplication of information to the board. So it does sound like you guys know each other and maybe have been having some open lines of communication. That's great. I would encourage you to do that prior to the board hearing. So let's start with the time allotment for introduction. And I do want to say too, just for everybody, when we go before the board has a full day. This is far from the only item that lines up on the board's agenda. So I do have to be mindful about the amount of time that I can allot for this particular hearing. So let's start with the division. Do you have an idea of how much time you think you need for the introduction?
Yeah, 10 minutes should be sufficient, Michael, to introduce the site.
Thank you. So from there, we move into the presentations, and our standard order of presenting is division, and then the operator, and then the objectors. Division, how much time do you think you need for your presentation?
35 minutes.
Okay, and for Aggregate Industries?
I believe there's going to be 14 items that are issues before the board. So I don't want to be excessive, but would 75 to 90 minutes, somewhere in that time frame, seem to be acceptable?
I think with knowing we're going to have to add additional time for rebuttal and closing, that might be a challenge with the overall total time that we want to allot for this. We can put that.
How about 60 minutes for our initial presentation? Is that, or are you looking for something closer to 45 minutes?
I think certainly if we could do 45, I mean, let's see where that puts us. And when we kind of get through with this exercise, where we're at with the total amount of time.
Okay, let's start out with 45 then, please.
Thank you. Okay, and for the objecting parties, again, understanding that this time allotment would apply to all three of you, how much time do you think you would need to present to the board?
This is Wayne Mueller, 45 minutes.
Does that everybody agree there that that would be sufficient for the three parties?
No, that's for all. Hold on just a minute.
That was just for me, 45 minutes.
He's asking for all objecting parties. 2 hours?
I'll just say, I think those times are going to be excessive. Right now we've got the division at 35 minutes, the operator at 45 minutes. If we can try to stay somewhere in the ballpark of those, I think that would be a good starting point. Ms. Gould?
Yeah, I wanted to clarify in that time frame, is that with us, bringing in witnesses, or is that just us making a presentation? Or
Yeah, this would count for, good question, count for your total time, including any witnesses that you have that will be giving testimony.
And any cross-examination.
Yeah, cross-examination would come out of your time.
No.
I have no experience to, make a decision off of this with, but looking at, historically, the facts with the whole application are pretty well known. I think that there should be more time given to the objections because they're raising the parts that are not known. This is the discovery part that, we want to be able to say, hey, this is what everybody else sees. This is what everybody else also needs to see. I can't tell you how long that would take, but there are a lot of little things in this, and I can't picture three of us bringing in witnesses, talking about our individual things being accomplished in 45 minutes. On the other hand, maybe we get up there and speed right through it, but I want to have it. I don't want to be in a situation where, well, sorry, you're done. You don't have enough time.
I understand this. Is there a number you guys can provide to me? With the understanding that I think 2 hours is going to be excessive. And again, as I stated, this is not the only item that the board has to consider that day. So I need to be mindful that when I'm creating this draft pre-hearing order that the board gets to all of the business scheduled for that day. And I do understand there is another contested application that's going to take some time. And so I think, to the extent that we can try to keep this entire hearing somewhere around the 3 hour mark is going to be appropriate. And again, this is a draft order, and if folks, at the end of the day don't agree, there's an opportunity to raise this with the board, and at their discretion, they can modify these times.
This is Mike Lloyd. What about 90 minutes?
I can, we've got a rebuttal and a closing too, so just, keep that in mind. This is not your only opportunity to be able to address the board. So you're going to have another chance to respond to the other testimony that you hear, which
and that does not count against our time.
I'm sorry?
Rebuttal does not count against our time.
Well, you have rebuttal time that is allotted specifically. If you cross-examine another witness, that's when that'll come out of your time allotment. But just the rebuttal itself is a time we set aside. So can we try to limit this to 60 minutes as a starting point? We'll see where we fall out as a total time frame when we're done, and if we need to, we can adjust some of these.
Well, I guess we don't have any alternative. That's what you're saying. It needs to be.
And this is Wayne Mueller. Understand that Mike and I have history appearing before the board on this permit when it was originally granted. And they limited our time, and we never got to say our objections at that one. Literally, we were given 15 minutes and shut off. And that's how this whole process started. So we're a little gun shy on this end.
Just to give you some background, Wayne and I have both lived here for over 20 years.
Understand that. I know you guys have a lot of site history. I know you can talk at length to the board on a variety of different topics, but part of the exercise that everybody, not just our objecting parties, but division staff and the operator needs to go through is having a concise presentation for the board and just being able to get right down to the issue.
We will.
I just
We
want to say,
assume
right,
Yeah.
right now we're at 2.5 hours total, and we have not allotted time for rebuttal or closing. So let's go ahead and move on to the next section, which is rebuttal. The rebuttal would start with our objecting parties. Now, keep in mind, we've gone through the intro, we've laid the groundwork. The board at this point has heard 3 different presentations. So generally, when we get to the rebuttal, this is a shorter amount of time frame that we would allot for rebuttal. But with all that being said, what sounds like a reasonable time frame for rebuttal for the objecting parties?
Can I ask a question real quick?
Please.
I apologize, but I wasn't sure I was 100% clear on what the time frame was, what was set on the last, was that 60 minutes?
We have 60 minutes right now for the objector, 45 minutes for the operator, and 35 minutes for the division. So, just keep that in mind. Right now, the time that you asked for is almost twice the amount of what the division is going to need to make their presentation. Yeah, but we're on to the rebuttal for now. Do you guys have a sense of how much time you'd like for rebuttal statements?
I think 20 minutes is probably adequate. That all, that could change if something is presented by the permit holder, and that changes how much time we'd need. Right now, 20 minutes should be adequate for me and for Mr. Lloyd.
Got 20 minutes down. Aggregate Industries.
15 minutes for rebuttal. I mean, we can go less if we need to, but let's start with 15 minutes. And I just wanted to clarify, Mr. Mueller just said 20 minutes for he and Mike, but it's 20 minutes for all the objectors, and it's not subject to change unless the board changes it when it moves to either accept your draft order or revise it.
Thank you, yes, for that clarification. And I guess just to circle back to the objecting parties, Ms. Berger is right. I have 20 down for the entire group. Is there agreement that that'll be sufficient?
This is Mike Lloyd. It appears it's sufficient to me.
Ms. Gould?
I'm laughing because I have no experience in this, so I guess, yeah, sounds fine.
Okay. Division?
Sorry, muted there. 10 minutes.
Thank you. All right, that takes us to closing. And again, generally, you can see that as we got into rebuttal, we've got some shorter time frames. These are just your parting statements to the board. So this should be, relatively short in time to the extent that we can do that. Our closing statements are going to start with the objectors, then the division, and then the operator will have the final closing statements for the hearing. For our objecting parties, how much time would you like for closing statements?
10 minutes is adequate.
Division?
5 minutes.
And for Aggregate Industries?
5 minutes.
So I will recap what we have down currently. The division will start with an introduction of 10 minutes. Presentations will start with the division at 35 minutes, followed by the operator with 45 minutes, concluding with the objector at a full 60 minutes. We'll then move into rebuttal, where the objectors will have 20 minutes, followed by the operator with 15 minutes, concluding with the division at 10 minutes. And then finally, our closing will be the objector with 10 minutes, the division 5 minutes, and the operator with 5 minutes. That is a total of 195 minutes or 3.25 hours, which, considering the number of objecting parties and issues that we have raised, I think is ample time to be able to consider this item before the board. Are there any further comments, questions, discussion points? Ms. Gould, I see your hands up.
Yeah, I just need a little more education trying to understand in reading what was sent out, that there are individuals that can also speak at this hearing that are not a party to this, but can as a public speak. Is that correct?
Well, there's two aspects to that. There are witnesses, which you can call, and that is part of the witness and exhibit list that you'll be providing to us today. So if you have listed somebody out, that would be an individual that you can call directly, provide testimony that will come out of your time wherever they provide testimony. But you also might be referring to the public comment portion of the hearing.
Correct.
In which there is one at every hearing. Keep in mind, the board will open it up to general public comments at the conclusion of the day's business. So it's not necessarily tied to this particular hearing. It is at the end of the day, once all of the items have been heard, the board will open it up for public comment. If there are members of the public that would wish to provide comments on this application or anything else, they can do so at that time, but it will be at the end of the day.
Okay, thank you.
Anything else before we wrap up? I know we've gone a little bit over. I appreciate everybody's time and patience. Thank you for joining us today. I know we covered a lot of information. Again, I think we landed at 3.25 hours. I will have this draft order out and disseminated to everybody by next Tuesday, close of business. If there's any questions on that, you'll have my email. You can reach out to me. Otherwise, we will see everybody on the 19th at the board here.
Michael, just one thing. I was adding up the hours and I'm at 215 minutes, unless I'm missing.
And 15 minutes.
Mm-hmm.
I think the 10 minutes for the introduction may not have been factored in the original calculation.
Probably exactly what I did.
Oh, but that'd be a 20-minute differential. My apologies.
Yeah, I've got 210 as well, Michael.
Oh yeah, apologies. I've got an error here in my spreadsheet, I think. Good, 210. Okay, so we're right at 3.5. Apologize. This will be all spelled out per presentation in the draft pre-hearing order. Thank you for that correction. Anything else? Second. All right. Well, thank you again, everybody, for your time. And have a nice day.